panellist is VTA's industrial advisor. Paul's obviously been around the traps for many years and has dealt with numerous union officials and employees and has a vast amount of experience. So, Paul, if I could ask you first off, in terms of the industrial landscape, what are you seeing in terms of lockdowns and in the COVID area that we're in?
Look, the issues, I suppose, around that, Cam, go to an employer being aware of or being able to find out whether some of their workers have been vaccinated. Secondly, I guess the reverse of that coin is can they mandate vaccinations? And the final point is what approaches an employer should take at this time when dealing with COVID and vaccinations. So let me try and take those in I'll take them in the reverse order. The first thing I think any employer should do in the current circumstances is develop a policy around COVID, vaccinations, information. If you've got a policy, you're in a defensible position. If you just go out in a half-assed fashion on a regular basis, that's what will happen. It'll become half-assed. So the federal government have made it pretty clear that they're not going to mandate vaccinations. So the only way that vaccinations could be mandated is if they come out of a public health order at state level, and it doesn't appear as though that's going to happen for the transport industry. It's happened for aged care, and it's happened for some in quarantine and healthcare. The Prime Minister 2 weeks ago talked about a 4-tier system, and that's now been adopted by the Fair Work Ombudsman. Bear in mind that this is not any set of binding rules or regulations. It's an attempt to just help employers come to terms with what they might need to do. Now, we probably fit, when I say we, the transport industry, probably fit into this 3rd tier, workers who face the public in their daily work. We're talking about retail, supermarket, things of that nature, working in essential occupations where there's a lot of contact. Your ability to ask an employee to get vaccinated is based around a lawful and reasonable directive. That's the common law test. So and it will happen, SPC, for instance, have mandated that their workers have to be vaccinated by a certain date. Qantas have mandated that anyone who works at Qantas has to be vaccinated, has a first shot by November, then a second shot, I think, by March. It's going to happen in the transport industry where you have a client who says, we only want vaccinated people on site. So that raises 2 issues. One, you've got to obtain that information from your employees, and that's perfectly okay to do that. It's no different in my mind to checking that they have a driver's license that meets the vehicle they're driving. Can you mandate that they get vaccinated? That'll get tested in the Fair Work Commission and in the court system. It's probably unfortunate that that's how it's going to work through, but that's what we've been left with.
Do you know or have you heard if the Transport Workers Union has a view on that? Is the TWU, have they put a line in the sand?
The TWU will support companies who make lawful and reasonable directions. The TWU are considering their position on the wider perspective on both a national and state basis. But, you know, given that they have employees who work at Qantas, you know, you can see that Qantas is mandating vaccination. So I'm not sure which way they'll jump. And I know that they'll work through the issues pretty thoroughly. That's not probably the the best answer I can. Well, that's the best answer I can give you, Cam. But time will tell exactly where they'll fall in that respect. And look, I will continue to talk with both the federal and national and the state branches around their expectations of this.
Because you'll see that come this weekend, and I know my business is certainly preparing for it, about movement from LGAs and having a testing regime in place, which would have to be done by a third party versus someone proving that they've had their first vaccination in a permit process. So there's one way of trying to able to establish whether or not your drivers are at least had some sort of vaccination. So I suppose there's a process you need to be, would you say you need to be careful about trying to get that information?
Well, you need to respect any such information you obtain, and if it's a government requirement, then that's okay. But you may well need to ensure that there's some privacy protections around the information you do obtain.
Well, just as if I move it, then what in terms of obviously COVID, we saw 12 months ago, that the EBAs were, a lot of the large companies put their EBAs on hold. They bought 12 months. They had a memorandum of agreement. The whole thing's over for 12 months. Where do you see EBAs and negotiations on at the moment? And what sort of quantums are, one, are they occurring? Two, what quantums are they looking at as far as base rate increases or any terms and conditions?
The last analysis I did of enterprise agreements in the system for processing, which was about 3 weeks ago or thereabouts, indicated that, well, you might recall that the Fair Work Commission in July provided a 2.5% increase. Following on from that, most of the EBAs in the system are between 1% and 3%. And if I had to pick an average, I'd say about 1.7, 1.8%. Now, it's an interesting question as to whether, and I haven't seen any, but sooner or later there might be an enterprise agreement that says we want agreement to mandate COVID vaccinations. There's no reason why that couldn't be included because it's a workplace issue. But as I said, I haven't seen one, and that's something that we can keep an eye on moving forward. But to answer your question more directly, round about 1.7, 1.8%, Cam, I've heard on the grapevine, I'm not sure if anyone from Toll's on this, but I've heard on the grapevine that Toll will be going on strike on Friday. Well, not really the grapevine, it was in today's age. And I understand that that's on the basis of protected industrial action. And I understand that some of the other companies, FedEx and Star Trek, might be subject to industrial action in the next 3 to 4 weeks or so. So
for our members that have got EBAs or EBAs coming up, do you think that that's what we're going to see? Is that will the unions be wanting to replicate that from the the large CNTs and the tolls and what have you? Do you think that's going to be, you're going to see industrial action, or do you think it's just a statement?
Look, I think at the top end of the market, that's where they always start their campaigns. I think they will try and flow things down, but if you're close to your employees and if you're close to your clients, then you can avoid those type of situations, I suspect. So certainly the TWU have tried to pull everyone, as many as they can, in together, but they've probably covered maybe 10% of the market maximum.
But there have been other EBAs that have gone through of late?
Yep. And
what durations are you seeing in terms of time? Are they going for 2 to 3 years, or?
Look, the maximum you can have is 4 years. If you could get some degree of certainty over a 4-year period, that may not be a bad thing. I suspect, or my indications are most of them are between 2 and 3 years. There will be the current federal government have indicated that they will bring industrial relations back on the agenda. If you can get a 4-year deal, then that's probably beneficial because you can bypass some of that stuff.
And what would you say is, you obviously field inquiries from members on a daily basis. What's the most common thing that you're getting from members and questions about, obviously in COVID in the industrial landscape? What's their biggest issues?
Look, the top couple of issues are around casual employment. You've probably all read or heard that the High Court overturned a decision in the Rosado case. The federal court had determined that Mr. Rosado was not really a casual employee because of the nature of the whole relationship as distinct from the written contract of employment. So what the High Court have said is that you go to the written contract, and if the written contract says A, B, and C, you follow the written contract. If the written contract says A, B, and C, but it's really a disguise or a sham, then you look at what's beyond that. You look at the behaviour of the people involved in any employment contract. So, in terms of the Rosado case, what should you do? You should ensure that any engagement of a casual employee is done in writing, with a clear statement around the casual status of employment, and that any employees are paid a casual loading in place of annual leave and personal leave. And please make sure the casual loading is identified on pay slips. Part of the problem in that Rosado and those or the WorkPack cases was that these individuals were paid $50 or $60 with no identification of a casual loading. So please ensure that if you have casuals or you're engaging casuals, do it in writing and spell it out very clearly. At the same time, because the government amended the Fair Work Act to put in place a conversion from casual to permanent in certain circumstances, the new provisions, so this was introduced in between the federal court decision and the High Court decision, but it's still law. So the new provisions create a positive obligation on employers to determine whether casual employees who've worked for their employer for 12 months meet the eligibility to be converted to a full-time or part-time. The criteria are employed for 12 months. Such employees worked a regular pattern of hours for at least 6 months. These hours will continue to be worked if that employee was to become full or part-time. And you've got to provide them with a statement about casual employment, and that can be downloaded from the Fair Work Ombudsman's website. The High Court determined that you can have a casual employee who might work 6 months, then have a break, and then work another 6 months, and then have a break, and they're still a casual employee. You come back to the written contract. So what you need to do with respect to this casual conversion stuff is identify casual employees employed prior to 27th March, write to them, and if they meet the eligibility criteria, write to them and offer conversion to full or part-time employment. You can refuse on certain grounds that the employee has not worked a regular pattern of hours, and there are reasonable grounds to believe that the job being performed will cease to exist within the next 12 months. So it's important that you do that because that's now new laws, and the Fair Work Commission will be varying the awards. Sophie, my grandchild just came in she'll probably provide better advice than me.
You'll say that, Paul, we were getting some expert opinion coming in there, or expert advice. Okay.
So she said, could that man with his mask on please take it down? He looks like a pedo. So what you need to do is the Fair Work Commission are varying the awards to now take into account the new arrangements that have been legislated. So that's happening over the next few months as well. What is it? You don't work with animals and children or something, Rob?
Just another one, the Wage Inspectorate. Are we seeing, last year we were hearing that they would be active. Heard of some businesses had received visits from them. Obviously, COVID would have slowed that down. What are you hearing? Are they going to ramp up again and go and inspect people's businesses and their payrolls, or has that gone away and we don't need to worry about it?
The Wage Inspectorate has now appointed its commissioner. I'm still trying to get them to forward a prosecutions policy, and they've been out and about doing desk audits. That doesn't really help much. I mean, most of the Victorian public servants haven't been in the office for 12 months, from what I can gather. So they've been out and about, Cam, virtually, but they haven't really. At our last Transport Industry Council meeting, I asked them to provide some evidence about. This is very hard. To provide evidence about what's happening in terms of deliberate underpayments and things like that. Up to this date, Cam, I haven't had anything. So
something to stay tuned for.
Yep.
And just sort of in closing, and obviously we take on board, what may or may not happen as far as being able to mandate having people vaccinated in your business. But I think the takeaway for me is to make sure you have an overall policy on it. Do you think the unions will be pushing for like leave days to go and get tested or vaccinated, those sorts of things? Do you reckon that's on their agenda? So should we watch out for that if we're currently negotiating EBA?
Certainly, because the ACTU has a policy of providing leave for vaccination, and then if you get a bad reaction, people need special vaccination leave. So yes, the short answer is yes. Just two other things I wanted to cover off on. There's a federal court decision that says an employee engaged under the local award can't work under the long distance award. That decision, in my view, is wrong. And we've written to the Fair Work Ombudsman indicating that the long distance award has an allowance that enables a local driver to work under the long distance award and be paid accordingly. And this is just for general information. Menulog has sought to make an award for the on-demand services industry. Menulog is one of those meal delivering companies that employ drivers as distinct from contracting drivers. We've taken the view that delivering a cooked meal to a punter is no different to delivering a parcel or whatever else it might be. Whether you're using an app or a phone or the internet or whatever is irrelevant. You're moving a bit of freight from A to B. And so we will be very firmly and very clearly stating that the Road Transport and Distribution Award covers that. Now, why is that? Why am I mentioning it here? Because the oil and distribution part of the Transport Award is in the Transport Award and it has specific arrangements for oil and distribution workers. If this Menulog application was to get up, then every part of the industry that thinks they're special will go and apply for an award. And that doesn't, 10 years ago, we got rid of 4,036 awards and brought them back to 120. So that's just for information. The other useful bit of information is Uber is being prosecuted by their ride sharers group for failing to keep proper records. For that prosecution to succeed, the threshold issue of are they employees has to be determined first. So it raises an interesting question about, it's a backdoor method of determining the employer-employee relationship versus the contractor relationship. Now, the High Court are also considering a couple of cases following Rosado around employment versus contractor. And they're on the agenda for the next 6 months. So it'll be interesting to see what we get out of those decisions, and we'll certainly keep you informed and advised.
Will we see Uber Freight?
Sorry?
Will we see Uber Freight is the challenge, is the concern?
Oh.
In the gig economy?
Yeah, sure, we'll see. We'll have Uber Waste, Uber Cash, Uber Freight, Uber Fuel. Why not? That's their model.
And where do you see, in terms of what you're hearing from state regulators and what have you, are they supportive of something like that, or are they understanding of the challenge you have with that and what that does to an unregulated industry?
No, they don't understand, but we continue to push. We continue at the Transport Industry Council to ask for, that's a Victorian-based body, to ask for the Wage Inspectorate to get out and provide some regulation in that part of the market. Because, we know that Uber is taking work off freight companies.